Defense, as a proponent of this evidence, please make your argument.
Judge, in the ever-evolving medium that we live in our society with utilization of video and video cameras and photographs, so on and so forth, it would be archaic for us not to take into consideration all the collateral pieces of evidence that are part and parcel associated with what potentially is going to be the structure and advent of the future of evidence. That being said, shadows and light are the most basic concept of how images are formed. Mr. Schumacher testified that he's been utilizing a slew of factors, including shadows and lights, to make a determination during his accident reconstruction situations for years. He cited cases. He cited a case out of North Carolina where the prosecution actually used shadows. He cited articles that he's used, training programs that he's gone through, and there's software that he utilizes to be able to further validate what he's doing. Judge, this isn't witchcraft science. I don't think you could ever get one witness to take the stand and say, listen, using shadows, given the fact that he went in, he has the actual video of what was used, he actually went to the location of where the incident took place and did his own independent evaluation where he himself cast shadows to make a determination as to where the shadows were coming from. I mean, the prosecution says his testimony is not based on sufficient facts or evidence and is not the product of reliable principles. Shadows and light are the basic elements of photography. What the prosecution's in essence saying is photographs are not reliable. We have a real life.
Let me stop you there, because I have heard the state argue differently. It's my understanding that the state, and correct me if I'm wrong, state, is that the state is saying that the interpretation of shadows is the issue here, because isn't that ultimately what you're asking Mr. Schumacher to do, is to take the shadows, which are, I believe you indicated, on the sink in this case, to enlarge them and to interpret them, not based upon a reconstruction of the room, but based upon what he sees in that video when he's enlarged it using his computer program.
Judge, shadows are in essence a fingerprint of a person's body. Okay? And so what he's doing is he's using the visual evidence that we all have, which is the surveillance video. He's gone to the scene. He's gone to the scene and he's done his due diligence. I mean, he gave you kind of a snippet of what he's done, but he went there and he was able to make a determination of, based on where he was positioned, how those shadows play, how those shadows reflect. He said, well, I stood I see these shadows, and I went into the kitchen myself, and I said, well, listen, let me stand to see where that shadow falls, because that is going to be indicative of where the person that cast the shadow was.
But then didn't he just testify in this courtroom that he was not asked to use the correct lighting in his reconstruction?
Judge, I don't think that, I think that that's an issue for cross-examination. That's something the prosecution can use to attempt to discredit his theory, but I don't think it goes to his admissibility. The issue here becomes this, Judge. The prosecution, as I've told you, they've made a huge ordeal that Jennifer Alfonso was in the kneeling position. They took the dummy, they put it on its knees, and they had Emma Lou insert the dowels in her as if she was getting shot on her knees. He clearly states that nobody on their knees in that kitchen can cast a shadow. He did it himself. He tried it himself. It wouldn't cast the shadow. So at 7 a.m., 33 minutes and 33 seconds, both figures were standing. He's got to be able to testify to that, Judge. He personally went and did an analysis himself. Now, with regards to, I think I would urge the court to look at State versus Kevin Dowling, which is a Pennsylvania case where the defendant there was convicted with the use and applications of how shadows are used. I don't think anybody.
Do you have a case site for me?
We're in the process of getting a case site. We're in the, Judge, here's the issue. And obviously this is, a difficult scenario because it's the last minute, and I do want to add, that Mr. Shoemaker, it was Shoemaker, Judge, not Schumacher. I was mispronouncing his name the whole time. But Mr. Schumacher was in the hospital yesterday, and I understand the prosecution went with Miss Dunn and Miss Klein, Mr. Dunn, and Detective Ruano. And if you read the transcript, it appears that all three questioned my client in his hotel room as he's recovering. So I understand that, they're going to make a point that he didn't remember the exact number, but what we have to do here is we have to understand this. This is somebody that takes a totality of his work and makes a determination, okay? Now, in this case, there are specific things that we've looked at, that he's looked at, and that he's made a determination based on the physical evidence that's there. And when he does his reconstruction and makes a determination of Jennifer Alfonso's positioning and her positioning when she was before she was shot and before she was shot and at the moment that she was shot, these are things that he takes into account. And there's multiple variables, one of which is the shadows. And I think it would be unjust. I think that the jury needs to hear this. The jury needs to hear this man say, "I went into that hallway, and I went into that kitchen, and I stood where the shadows project." And if somebody was kneeling, this shadow wouldn't be projected, because that discredits the government's case and it credits our position. We have to be allowed to do this, Judge. I would implore the court to understand that this goes to the this goes to the underlying premise of our defense. Our defense at this point, we haven't been able to elicit certain types of testimony that we were hoping to. I understand the court's rulings while we respectfully disagree with them. But at this point, we're left with Mr. Schumacher. And not being able to have him testify, for at least the defense to be able to air a position with regards to Jennifer Alfonso as to whether or not she was standing or not, how he looked, what he did in terms of looking at those shadows. And I'll tell you, Judge, there's also an issue where he testifies. He goes, "Listen, I zoomed in the camera, and I see an object at 7 a.m., 33 minutes and 33 or 34 seconds. And they're like, well, can you tell what that is?" He says, "Well, I can't tell if it's a knife, but I'll tell you what, it's not a gun, because it's not cylinder in shape." And that's...
Let me hear from the state.
Judge, I don't even know where to start, quite honestly, so I'm just going to respond to immediately what defense counsel just said and then sort of go back. First of all, to say this shadow is a fingerprint of a person's body, with all due respect, defies common sense. Forget about any legal argument. Because, Judge, if I do this and make a shadow, there is not a bird in the room, but yet the shadow would indicate that there's a bird in the room, or bunny ears, or if I stand back so my shadow looks like I'm 6 feet tall and a size 2. So with all due respect as to that argument that it's a fingerprint, it's hardly a fingerprint at all. In fact, it's actually the opposite. It's completely unidentifiable as to what it is. The second thing, Judge, as to factually what defense counsel is arguing about the mannequin being on its knees and all of that, Judge, first of all, their expert, Dr. Bodden, was very specific and said for a long time, repeatedly, even to Mr. Dunn on cross-examination, he told Mr. Dunn he was wrong, that the victim could have been standing for numerous seconds. And then they followed up with Mr. Tisa to say that he could fire the gun in 3 seconds. So there's ample testimony. In fact, even from Dr. Liu, under the grueling cross-examination by Mr. Padilla, did she say that it is completely possible that for at least one, if not some of the shots, the victim was standing. So as far as the record being devoid of any evidence that the victim was standing, for the defense to be able to argue, or this being a hampering of their ability to argue that, the record is replete with opportunities for that, should they wish to avail themselves. Moreover, to say that this witness would say that she had to be standing is incorrect. I've asked for the deposition to be marked, Judge, and in fact I specifically asked Mr. Schumacher yesterday, well, isn't it possible for someone to be on their knees and waving their hands, and that would create a shadow? And what did he answer me? That the person would have to be at least 5'6". Well, Jennifer Alfonso was 5'6", Judge. So I fail to see how specifically him saying she has to be standing is factually consistent completely with this case, and he's the only one who says that, because in fact their own expert will tell you that at 5'6", she could have been on her knees and waving her hand. That's as to that. Judge, you know, the state not only respects but appreciates the great lengths that the court has taken in this case to make sure that the record is well preserved. But with all due respect, Judge, on this one, we're not even close. First of all, we did a Westlaw search because he talks about these cases that he's testified in. And I would be remiss, Judge, if I didn't bring it up again, that all of those cases are something that had we been provided with all of this in advance, we would have researched, we would have pulled every single one of them. But when you do a Westlaw search under shadow analysis, under visual brainstorming, under crime scene reconstruction for purposes of shadows, or under shadow rotation, you come up with 0. So we would be looking up all of those had we been given this information on time. Moreover, counsel tells you that part of the validity is his own self-validity of looking at photos and looking at all his scans, Judge. He says he relied on those. The state has never, to this day, been provided. So even if counsel says, like the other day, that he made a mistake and that, in fact, this was all contemplated and it wasn't a Richardson violation then, how on earth could the state prepare for a situation where he himself says, and counsel just said, Judge, he looks at the totality of all the circumstances of all the work he did, but we don't have all the work that he did, Judge, because counsel has failed to provide it to us. And based on the deposition that consists of a minimum of 15 photos and 30 scans of the house, where we would have then had the opportunity to go out and find our own, I don't even want to say the words shadow expert because it doesn't merit that, quite honestly, but that is what we would have tried to do. Judge, the standard for expert opinion evidence is that it must be based, on methods and procedures, rather than on subjective belief or unsupported speculation. The court is all too familiar with that. Moreover, Judge, based on the battered spouse syndrome case law that we looked at previously in this case, there is no abuse of discretion for this court to not accept an expert. The only difference is that at this point, the state would not have any remedy in terms of being able to take cert. But as far as the shadows go, because I'm going to address the black thing in the corner after, but as far as the shadows go, Judge, there's been 0 method and procedure. What did he do to determine the shadows? He enlarged the video and slowed it down. Well, Judge, that's already in evidence, okay? The jurors have that. In fact, that's in evidence ad nauseum because they recalled Mr. Coleman for that purposes, and if the slowed down video wasn't enough, they then put in the stills through our detective because Mr. Coleman wasn't available, okay? So right now, the jury has exactly what this expert has. Then what did he do? He himself walked through the house 9 months later, because his depo says he did it in April, and I have no reason to think that he's mistaken about that. 9 months later, he goes to the house, he walks through the house, in his depo he testifies, he's not even sure what the lighting was the day of the incident. He thinks it was 60 watts, he's not sure. He gets the lighting information from the defendant's father, who says to him, yep, these are the same lights as that were there, no idea, and specifically says here and there he did not recreate the lighting exactly. Well, if lighting is so important, then how could you not recreate the lighting to be able to give an opinion that the shadows were the same? And then, if that wasn't enough, what did his entire analysis consist of? Him going in the kitchen and moving around to see, oh yeah, look, there's the shadow. Not documented, not verified, absolutely no studies out there whatsoever in this, not published in this area. If this is so common and so basic, then there would be something, anything on this No validation whatsoever, and the court is right. Dr. Boland's study in 9 cases over a period of months, okay, was excluded based on the fact that she had not been peer-reviewed and that it was not validated. And yet here, we're going to talk about something that their own quote-unquote expert, by his own admission, says is a precise science, and yet there's zero validity. He didn't even preserve his work. He didn't record his work. It's completely subjective. And other than it's certainly not peer-reviewed, he's certainly not published in it, he can't even cite to anything because all of those other articles and crime scene books that they talk about, Judge, are all about how to recreate, if you are recreating a scene, to make it look accurate for purposes of reconstruction, not for purposes of using shadows to actually identify the placement or who somebody is in anything. And what else did he rely on, Judge? Every other thing that the jury already has. He's done nothing more than scroll up on his computer and enlarge, which the jury already has.
If I may just really briefly.
Briefly.
Okay. For the prosecution to make a attempt to make an analysis in the distinction between Dr. Boland's impromptu
You don't need to make that argument. You can continue.
Okay. Laboratory testing of alpha. Okay, well, that's apples and oranges, Judge. That's degradation of alpha PVP, a novel drug, versus shadows, which is a basic concept that anybody that does any kind of crime scene reconstruction or recreation takes into account. Now, they want to say, well, there's nothing that specifies shadow analysis or shadow imaging. That's because shadow analysis and shadow imaging are part of a broad, it's a sliver of a much broader, much more common time frame, a bigger theme, Judge. And listen, Judge, we're not splitting the atom here. It's simply going into a kitchen and seeing how shadows are cast. Very simple. And the issue here is this, Judge. When Mr. Schumacher did this, he internally did work, which was his work product. He never turned it over to us. We didn't have it. So the aspect that that's a Richardson violation, we've never had what he did. He never told us with regards to that he took these pictures. He gave us a position with regards to Jennifer Alfonso's position in the kitchen and her positioning when she got shot. That's what he told them on October 13th, prior to trial starting, when they deposed him. They didn't ask the right follow-up questions. They're sitting here, they could have asked him, well, how many...
You're going off field.
Well, okay.
States the issue of Daubert.
Right. Well, and then the issue becomes this, Judge. It's the most common application of light. Light and shadows are, it's black and white, light and dark. This is, in essence, what he's going to be testifying to. He's been doing it for 20-something years. The prosecution states in their motion, and I want to read the exact language that they use because it's relevant here, Judge. They state that the testimony is not based on sufficient facts or data and is not the product of reliable principles. The data that he used is exactly what the prosecution has, the videos. He went into the actual room. Moreover, the witness has not applied the principles and methods, reliability of the facts to the case. He specifically stated, Judge, what he does comports.
Okay. I've heard enough. Thank you. Okay. At this time, with the record being laid, I want to be very clear here. The defense has proffered Mr. Shoemaker, I apologize. Mr. Shoemaker, to be able to interpret shadows that can be seen on the video in the curved portion of the sink. Mr. Shoemaker clearly is very qualified in doing reconstructions, but that is not what we are talking about here. We are talking about analysis. He has provided no method and procedure for analysis of those shadows, no validity, no peer reviews. At this point, it is speculative. His use of shadows to be able to discredit things in the use of videos to show that a video was edited in a case in San Francisco is distinguishable from the case here. He is trying to take the evidence that is presented here, the shadows that are present here, and make a statement as to fact. And the court isn't going to allow that to happen. The jury has the videos, the photos. You can argue it and to the jury, but the court does not feel that under a Daubert statute that this defense has met its burden to present this evidence, and therefore the court is not going to permit him to testify as to shadow interpretation.
Well, Judge, will we be able to ask him if he went into the kitchen and found and positioned himself in accordance with what he saw in the video and where he was?
What's the relevance of that, Judge, if you can't testify to the purpose of it?
Well, first of all, wasn't there a motion in limine prior to trial where the defense said that you would not be calling him for that purpose?
That's correct, Judge, because it came up when we discussed the use of the other recreative visual aids that we did, which was the entire kitchen. The state objected because the state said that it didn't exactly replicate the kitchen, and at that point the defense said, we're going to withdraw them, we're only going to use these that Dr. Bodden is going to use, and then we said no problem, and that's why there was no need to call him.
Right.
At this point, I'm not going to permit it. You've laid your record quite well. At this time, the court's not going to allow it. You're trying to backdoor information that you agreed to exclude at the beginning of the trial.
Judge, if I just may lay a record.
Okay. You may, but we're going to be doing closings in 10 minutes. So if you'd like to lay your record at a future time, you may, but right now we have a jury that's been waiting again for a half an hour, and we're going to get to them.
No problem, Judge. What I'm going to ask is after the prosecution's done, I'm going to have to set up, I need to set up a visual I'm going to be using my own computer my own computer port, so I can have my team move certain things, which I'm looking for.
Okay, well, first of all, State, you obviously have open and rebuttal. How long do you anticipate your case taking? And we still have to talk to Mr. Medina about his election, whether to testify or not. Let's take that issue up first. Can you go, please, get lead counsel?